Hi everyone, welcome back to another episode of Let's Talk Legal with Karimi Chege. My name is Ashley Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 5 of Employment Law Unlocked, where we'll be talking about paternity leave. So what are the objectives of today's episode? 1 is to outline the law that provides for paternity leave as a right in Kenya. 2, to establish the conditions that must be met by a male employee before they proceed on paternity leave. And 3, can paternity leave be extended? And then we'll climax the episode with a case summary of the case of Benjamin versus Ministry of Labor and 6 others, a 2023 case. So let's get straight into the episode. So before we talk about the law that provides for paternity leave as a right, I'd like to just give a bit of perspective to this episode. So the law for paternity leave was highly influenced by our patriarchal nature, in that, as per our traditional gender roles, the women were mostly found in the private sector, taking care of the home and the children, and the men were mostly found in the public sector, working and fending for the family. However, this is not the reality of the world we live in today, and both male and female are participating equally in the public sector. So just have that in mind as we go about this episode. So what does the law provide in regards to paternity leave as a right? Section 29(8) of the Employment Act provides that a male employee is entitled to 2 weeks paternity leave with full pay. Kindly note that the law has indicated that it is a male employee. Therefore, the marital status of such an employee is not relevant. This person could be a spouse, a fiancé, or even a boyfriend. As long as he's an employee and has sired a child, he is entitled to paternity leave. The law also provides for a period of 2 weeks for paternity leave. So how is this 2 weeks calculated in law? This 2 weeks is calculated as 14 calendar days, which means that it is inclusive of public holidays and weekends. When does this right to paternity leave vest upon this male employee? This right vests after the birth of the child. Kindly note that these 14 calendar days that are provided in law is the base and not the ceiling, which means that nothing stops an employer from actually providing more paternity leave days to his employee. We can learn from the Teacher Service Commission, where under their 2021 to 2025 collective bargaining agreement, they provide that male teachers are entitled to 21 calendar days of paternity leave with full pay. Therefore, as you can see, it is just but the base, the minimum requirement under law, and not the ceiling. Under Rule 11 of the Employment General Rules, it provides that these 14 calendar days are entitled to the male employee per year. Therefore, even if you were to have multiple children, in the case of triplets or twins, you are not entitled to more paternity leave days because of your children, but the paternity leave days are pegged on the year. So no matter how many children you have in that year, you're only entitled to 14 calendar days. This also applies to polygamous men. If your 2 wives are giving birth in different times of the year, you're still only entitled to the 14 calendar days by law. Now let us talk about the conditions that must be met by a male employee before they proceed on paternity leave. Rule 11 of the Employment General Rules provides that a male employee should apply or make an application to his employer of his intention to proceed on paternity leave. This application should be in writing. The law does not provide a notice period like the way it's provided in maternity leave, but we can infer that this application should be done within reasonable time. And the law also provides that the application should be accompanied by evidence to prove the birth of the child. In this case, evidence would be a notification of birth. Do also note that as you effect service of these documents upon your employer, you should effect them in a way that you are able to prove service in the event that this service is challenged. We propose that you do either WhatsApp or email, and if you do physical service of these documents upon your employer, ensure that you make 2 copies of those documents, one which you will give to the employer and the second which the employer will stamp and sign as an acknowledgement of service. Now let us talk about whether paternity leave can be extended. The law is very silent in this regard, but we can infer that paternity leave, just like maternity leave, cannot be extended. But in consultation with your employer, you can request as a male employee to extend your paternity leave through the utilization of your other leave days that you have. That could be sick leave, compassionate leave, or annual leave, and those leaves you can use as a way of extending your paternity leave if you so wish. However, do know that this is only possible with the consent of your employer. Now let us talk about the case where the male employee's spouse or partner undergoes the unfortunate incident of stillbirth. Is the male employee still entitled to paternity leave? Unfortunately, just like maternity leave, the law is very silent on the issue of stillbirth. This means that the employee is left at the mercy of their employer, and we continue to beseech lawmakers to either amend the law or to provide regulation that tackles this unfortunate reality. This will ensure that such unfortunate incidences are handled by employers in a uniform manner. However, in the meantime, we can still beseech employers to ensure that they provide for this unfortunate reality in their policies or handbook. Now let us talk about the case of Benjamin versus Ministry of Labor and 6 others, 2023. So in this case, Benjamin was a consultant trauma and general surgeon, and he was working at Nakuru Level 5 Hospital under the county government of Nakuru. He filed a petition where he sought Section 29 to be declared unconstitutional for the mere fact that it was discriminatory. It was discriminatory, noting that it provided different durations of leave for paternity and maternity leave. You remember under episode 3, we talked about maternity leave being for 3 months, and now we've talked about paternity leave running for 2 weeks. So it is this differentiation in maternity and paternity leave that he deemed discriminatory, and therefore it violated Article 27 of the Constitution of Kenya, talking on non-discrimination. He justified this by saying that in the modern day reality, both men and women are given equal opportunities to work, and therefore he believed that both male and women were very important in the upbringing and the developmental growth of a child. He therefore averred that Section 29 assumed that the father had no critical role in the developmental stages of a child in their formative stages, and he said that this assumption is not based on any scientific, moral, or societal facts. He therefore stated that providing a lesser duration for paternity leave than what is provided in maternity leave was discriminatory and therefore unfair to both the father and the newborn child. The respondents in the case opposed this petition greatly and indicated that the 3 months maternity leave provided in law was important to give the mother a chance to rest after the gruesome 9 months of pregnancy. The respondents also indicated that it is the woman who carries the pregnancy to term and thereafter nurtures the child through breastfeeding and also heals from the physical process of childbearing. The respondents indicated that the men do not carry pregnancies and therefore they did not see the need of men being present for the 3 months duration just like women. Further, the respondents indicated that it would be very unfair to subject the employers to 3 months duration for paternity leave, since the employers are already tackling a heavy burden of the absence of childbearing women in the workplace. The respondents indicated that the main goal of government is to protect investment and to disapprove policies that affect investments. Therefore, the respondents indicate if they were to proceed with the proposal to amend paternity leave to now 3 months, this would affect families as companies would require to lay off their employees to protect their investment. The court was therefore found with a very hard question of establishing whether Section 29 of the Employment Act violates Article 27 of the Constitution of Kenya 2010. The court noted that not every differentiation amounts to discrimination and stated that the ultimate test is whether that differentiation is fair, justifiable, or it has a legitimate reason. In this case, the court noted that Section 29 has a justifiable reason because both men and women differ in their biological structure of hormones and genetics. The court noted that the biological changes that happen in a woman during the prenatal and the postnatal are not the same with what happens in a man, and therefore women require more time to heal and recover post-childbirth than men. Therefore, the court indicated that it would be unfair to treat both men and women in a similar manner, yet the differentiation is justified based on the amount of time a woman would require to just heal and get back on their feet post-childbearing. Therefore, the court, in making its determination, indicated that Section 29 of the Employment Act is not discriminatory because the reason for the differentiation is legitimate. So I'd like to pose a question to you. Do you think that the 14 calendar days provided as paternity leave is sufficient time for a father and a child to bond during the formative stages of life? If your answer is yes, I'd like to hear your rationale in the comment sections below. If your answer is no, I'd also like to hear your rationale in the comment sections below. Let us have this discussion and maybe we can help each other out on whether the 14 calendar days provided in law is indeed sufficient as paternity leave. That marks the end of episode 5 of Employment Law Unlocked. But stick around for episode 6, where we continue to talk about the benefits under the Employment Act. You do not want to miss this. Thank you so much for watching and see you on the next one. Remember, information is power, legal knowledge is freedom.